Hi folks, HR Funk here. Coming to you from the home office today. This is a little bit different venue, and the reason for that is because this is going to be a little bit different type of video. And this comes about as a result of a conversation that I had a few days ago with ERJG 1954. Some of you know who he is. And he asked me a question about police work. And after answering his question, I started thinking that there might be some other folks out there who have similar questions about police work, law enforcement officers, what have you. And I thought maybe I could put together a video and address some common misconceptions regarding law enforcement officers. Now, let me say at this juncture, this video is meant only for informational purposes. It is not meant in any way to be negative or condescending or anything else. I'm not trying to challenge anyone's beliefs or anything else. I am just trying to explain what I can about police work from my perspective. Now, some of you know that I have a long history as a law enforcement officer spanning about 3.5 decades. I don't want to go into a whole spiel about my resume or anything else, but I did retire about a year and a half ago, or I guess close to 2 years ago now. My last position was chief of police for a small agency here in Ohio, and again, that career spans back a long, long way. So I know something about police work, I know something about supervising police officers, and something about actually managing a police department. So with that all out of the way, let me jump into a few of these things. And this list is in no particular order, and I could have a much, much longer list. I just put this together this morning. If this is something you all like, please let me know in the comment section. I can certainly come up with more lists. And there are some of these topics on the list that I could make an entire video just about that topic or that question. So I'm trying not to do that. I'm trying to abbreviate this today and just, again, get some information out there that hopefully will be helpful for anyone who watches this video. So the first misconception I'll tackle is that law enforcement officers are all the same. And I can understand where this idea comes from. Generally speaking, we all dress pretty much the same. Officers within the same agencies many times are dressed identically. With the shared experiences and training and what have you, we all tend to talk similarly. In fact, there's an entire lexicon that's developed within the law enforcement community that's almost a language unto itself. And sometimes I can see where that could be confusing for anyone who was listening to it that was not familiar with the law enforcement community. But the reality of the situation is officers are as different and diverse, if you will, as any other group of individuals that you might have. And there is a commonality with the type of individual, or maybe I should say the type of personality of those individuals who are attracted to the law enforcement field. That's absolutely true. But again, you will get different opinions, different ideas, different ways of going about and handling things, depending upon which law enforcement officer you interact with. Now, something else that's not widely known is that agencies themselves, like the officers who work there, have personalities. The personalities really are determined by the chief executive officer of that agency, and through policies and procedures that are mandated by that individuals and people that that individual promotes as supervisors to oversee what the officers themselves are doing and how they're doing it, and deciding what is permissible and what is not permissible. And this will vary somewhat from agency to agency and definitely from state to state and jurisdiction to jurisdiction. So whereas you might have even agencies that are close together in proximity, you might have this particular law enforcement entity that will go about doing things one way, or this particular entity that will have policies and procedures that for one reason or another are different from the other agency. So you can tend to get a range of reactions to different, or excuse me, to the same situation depending upon who is responding to it. Very simply, one that I can point out is the agency that where I used to work would take traffic crash reports for crashes that occurred on private property. We were not obligated to do so, but we did so more or less as a courtesy to our citizens so that there would be documentation of who was involved, what happened, and for the various insurance agencies when they needed that information to have something that they could refer to get the information from. An agency very close to us does not take crash reports for private property accidents. That's just something in their opinion, they are busy enough to where they don't really have the time for the officers to spend taking traffic crash reports, so they don't provide that service. That's a very, very simple view of agencies that are very close together that will do different things or react differently to the exact same type of situation. And again, that changes very much, or that's very apparent with many different things that officers might respond to. So if you had an experience in one location with one officer on a certain type of incident, you may get a different response from a different officer in another location, or even the same location for that matter, on a similar incident in the future. And I point that out just to sort of underscore this idea that officers are different, agencies are different, and there's not really a one-size-fits-all to police work. And you will get, or you will see that difference in response depending upon who shows up and where something occurs. Next is something that I hear many times from people who are considering law enforcement as a potential career. There is an idea that officers hire into a department for a specific type of special assignment. For example, they are hired to be detectives, or they are hired to be canine officers, or hired to be SWAT team officers, or whatever. And I cannot speak for every single law enforcement agency in the country, or how everyone does things rather. But generally speaking, officers are hired into a police department, sheriff's department, or what have you, as patrol officers, or in sheriff's departments, they might be hired in as correction officers to oversee the jail. So everyone is hired, they go through basic training, they become officers, and they are hired in at that beginning level. Special assignments like K9, SWAT, detective, what have you, are assignments that officers can potentially move into after they have been employed for a period of time. And depending upon the size of the agency and the number of people who might be in line who are also interested in those positions, it might take a long, long time for someone to move from the entry-level position to those other assignments within the law enforcement agency. And this also goes hand in hand with something else that I wanted to touch on. Many times people believe that law enforcement officers basically all have the same knowledge of everything that could potentially happen in the world. And again, this changes depending upon their assignment. Patrol officers are the backbone of law enforcement agencies. Those are the ones that you see out on the street. They are doing the nuts and bolts work of things that take place within a law enforcement agency, and they are absolutely a necessity. But they might not, if they haven't moved into a position where they've been investigators or crime scene technicians or traffic crash specialists or whatever, they might not have that technical knowledge of those other assignments, which is, again, not to disparage them at all. It's just might be very, very good at patrol work, and depending upon when or if they're eventually able to move into those other assignments, they will have the training and gain the skills and everything that are associated with those positions. But if you have someone who went from patrol to, say, a detective's position, they might not have extremely technical skill of crash investigation or whatever. So again, you will have officers that are hired in initially to patrol work, or what I'll call entry-level positions, because again, in certain departments there can be other things. Again, I mentioned sheriff's departments hiring officers in as corrections officers or whatever. And after a period of time, when the agency gets to know that officer and understands how well they work as a member of the agency, how good an employee they are, their aptitude, etc. When these other positions come available, if there aren't others who are in line for those positions, then the officer may move up eventually, but they are not hired into those special assignments right off the street. So there are certain things that probably once upon a time were acceptable practices in the law enforcement community that over the course of time have become not acceptable practices. and this is one of them. There are times where children are misbehaving. They are not following their family rules, or they are doing various other things that are unacceptable to their parents. But those activities are not necessarily a violation of criminal law. And there are parents out there that have the idea that they can call the police, an officer can show up and take their kids into custody for some period of time to teach them a lesson. That, for various reasons, is not really done anymore. Again, I cannot speak for every officer in every jurisdiction in the country, so if recently this has happened where you live, then that happens there. But generally speaking, because of the liability involved with actually physically taking a child out of their home and putting them in a police car and potentially taking them somewhere else, not only is this potentially violating the law on behalf of the law enforcement officer for unlawfully detaining that child, but if the child slips getting into the police car and falls and hits his or her head, or if the police car is involved in a traffic crash, or any number of other potential things that can go wrong in that type of a situation, are reasons that is no longer an acceptable practice. And I have had that situation myself where parents have called, and I can empathize with the parents. They're at the end of their rope with this child who essentially is being a brat, but not really doing anything, not committing an assault, not really running away, not doing just, talking back or being disrespectful or whatever. Again, I get that. But once again, if there's not an actual violation of law, the officers are not really going to be able to take that child into custody and do something with him or her to get their attention. If the child commits a criminal violation, the officer may or may not be able to take them into custody depending upon a number of different factors, beginning with what exactly the law was that they violated. It's getting harder and harder in law enforcement to lock up adults who commit crimes, let alone juveniles who do so. And again, this changes a lot from jurisdiction to jurisdiction, state to state, when it comes to juvenile justice. And my perspective, once again, comes from Ohio law. But generally speaking, absent a criminal violation, the officer is not going to be able to take the child into custody unless there are some sort of extreme circumstances, like the child staying there is in some sort of danger or what have you. But here again, that expectation that parents can call the officers and have them take the child into custody and take them somewhere and teach them a lesson or what have you, really these days is no longer an acceptable practice. Now, this next one may sound like a rhetorical statement when I say police officers have jurisdiction over criminal violations. But I draw that distinction because if something is not codified in criminal codes as being illegal, then it's not illegal. There is no law written that gives people permission or makes something legal for them to do. The only time that something is codified into a law or an ordinance is when that is restricted or prohibited. So if something is not specifically made illegal, then it's legal. I hope everyone follows me on that. And again, this is not legal advice coming from me. This is just my understanding after 3+ decades as a law enforcement officer. So I'm making this statement because many times people will have something happen, or maybe someone else does something that they don't like, but that act is not actually in violation of any criminal law. And many, many, many times people will call the police and say that someone did this, or some organization did something, or what have you, that's maybe obnoxious, maybe it was impolite, maybe it's inconvenient or whatever, but it's not actually a crime. And officers can't address something that's not actually a crime. So I'm I could give example after example after example, but the bottom line on what I'm trying to say here is that if someone does something that an individual just doesn't like, but that act is not criminal in nature, officers are not going to be able to take an act to do something about it. Now, depending upon what the action is on the part of the other person and how it affects the person who doesn't like it, they may be able to contact an attorney, file a lawsuit, and address that civilly, but the police are not going to be able to take an action, make an arrest, write a citation, or what have you, if the act is not actually a crime. This next one is something we've heard about quite a bit in recent years, and it has to do with a law enforcement officer's ability to stop a citizen who is doing whatever the citizen is doing, driving, walking down the street, or what have you, for a law enforcement purpose. And there seem to be people on either extreme with this particular topic. There are some folks who believe a law enforcement officer can stop anyone at any time on a whim for really no reason whatsoever to investigate what that individual is doing. There are other folks who think that in order for a law enforcement officer to stop someone, that officer has to have absolute positive proof beyond any doubt whatsoever that the individual is committing a crime. And as is so often the case, the truth is actually pretty much right down the middle. Now, I should probably stop and go back a little bit in history. Prior to 1968, when a law enforcement officer stopped someone, that stop, if you will, was considered an arrest, meaning the officer would have to have probable cause to believe the individual was engaged in criminal activity in order to stop them. That changed in 1968 with the Supreme Court decision of Terry versus Ohio. And in that decision, the court decided that law enforcement officers had to have some middle ground between a full-blown arrest and just allowing someone to go down the street. And what they decided in that decision was that officers had to have a reasonable, articulable suspicion to believe that an individual was engaged in criminal activity in order to stop them to investigate what they were up to. If during the course of that investigation the officers determined that there was probable cause to believe they were engaged in criminal activity, then the person could be placed under arrest and whatever enforcement action there was going to be could take place. If it was determined they were not engaged in criminal activity, then the person was free to continue on down the street or do whatever they were doing. When we talk about a reasonable, articulable suspicion, this is less than probable cause, but more than just mere suspicion. And it has to be an articulable suspicion. It can't just be that I had this feeling, and every time I get this feeling, then I know somebody is up to no good. It's not that. It's got to be something that can be articulated, that based on the officer's observations, the facts or circumstances, or what have you, there was very good reason to suspect the person was engaged in criminal activity, but there just wasn't probable cause to believe that yet. If the officer has a reasonable articulable suspicion to believe the person is engaged in criminal activity, the officer can stop the individual to investigate that suspicion. Now, along with that decision, or that part of the decision in Terry versus Ohio, the court decided that if the officer has a reasonable articulable suspicion to believe the person is engaged in criminal activity, and the officer has a reasonable belief that the person is armed and presently dangerous, the officer can pat that person down for weapons so that during the course of the in the course of the investigation, the officer doesn't have to worry about being assaulted, injured, killed, or what have you. So this is the infamous stop and frisk. And so often I think there is a belief out there that officers can just see somebody walking down the street and think, hey, I want to stop that person and frisk them for weapons or contraband or what have you. And that's not the case. There has to be a reasonable articulable suspicion to believe the person is engaged in criminal activity for the officer to stop them in the first place. Now, if an officer stops someone and they conduct an investigation and they take that person into custody and charge them with whatever crime is ultimately charged. It is very common for defense attorneys to have a pretrial motion to suppress any evidence, a suppression hearing is what it's called, that came from that interaction with the officer if there was no reasonable articulable suspicion from the get-go to believe the person was engaged in criminal activity. And this goes to trial. The officer is there to testify as to what they saw take place, etc. The defense attorney can ask questions, and then a judge determines whether or not there was a reasonable articulable suspicion to believe this person was engaged in criminal activity. If not, then anything that resulted after that original stop is not admissible in court. So regardless of whatever happened, what contraband or weapons or what have you were ultimately discovered, if the original stop is not legal, then nothing else can be presented as evidence. The case can't go forward, and it's essentially done at that point. So this is important to keep in mind with this whole stop and frisk idea. It's not a willy-nilly, there's got to be something more than I just saw somebody walking down the street and decided to stop them and pat them down for weapons or what have you. The other thing, and sometimes police officers themselves get confused on this, is that the frisk part of the stop and frisk is for weapons. So if I find an object during a pat down in someone's pocket and I believe that it's potentially a weapon, and I remove that item from their pocket and it's, say, a pill bottle or something else, unless I can articulate some reason to believe that pill bottle is a weapon, or a weapon could be inside the pill bottle or whatever, I can't open that pill bottle to see what's inside of it, not legally. If so, that would be subject to suppression in the hearing that I talked about a little while ago. Actually, it would be if the stop was legal, but I took the search beyond the parameters that were permissible under a Terry stop, then any evidence that I found likewise could be suppressed, and again, there's no case to move forward. The next one, I think, is one that was created and definitely perpetuated by Hollywood, and this is the idea that if a police officer arrests someone and does not immediately, as they are applying handcuffs, read that person their rights, that any charges filed against the individual have to be dismissed, the officer gets fired, all kinds of bad things happen, etc., etc. And this is definitely a misconception. When we talk about advising someone of their rights, in law enforcement lexicon, that's called Mirandizing someone, or advising them of their Miranda warning. So named because of the Supreme Court decision, which is Miranda versus Arizona. I believe that was a 1962 Supreme Court decision, if memory serves. The Miranda warning applies to a custodial interrogation. Now, those are two distinct things that I want to try to clarify here at the very beginning. If someone is in custody, they're taken into custody, but they're not questioned regarding whatever they were taken into custody for, then they're in custody, but there's no interrogation. Therefore, Miranda doesn't apply. It doesn't have any bearing on what happens to that individual as it goes forward. If an individual is interrogated, but they are not in custody, they're not under arrest at the police department, they're not unable to get up and leave, walk out, what have you, then again, Miranda doesn't apply. It applies to a custodial interrogation. So if an officer arrests someone for an on-view violation, let's say drunk driving, and the officer is not planning on asking the person any questions whatsoever, they've arrested him, they're going to drive him back to the police department, they're going to process him, whatever, and they don't advise that person of their Miranda warning, it has no bearing on anything whatsoever. If the officer at some point after arresting the person and taking them to the police department or whatever decides that they are going to question them about whatever they're under arrest for, or any criminal violation, even if it's not what they're under arrest for, then the officer would have to advise the person of the Miranda warning. If they don't, then anything the person says during their verbal or written statement, or even if they provide a confession or whatever, then that would not be admissible in court. That doesn't necessarily mean the whole case goes away. If the officer gets in a hurry, makes a mistake, forgets to advise some of the Miranda warning, it just means that any statements they make can't be used in the prosecution of that individual later on. If, here again, someone is, say, in their home or wherever, they're not in custody, they are free to tell the officer, I don't want to talk to you, I'm going to leave, and they actually can leave, then again, there's no requirement for Miranda. The officer can ask them whatever kind of questions the officer wants to ask them, and that doesn't violate the principles of Miranda. So this is something, when I worked the street, I did not just willy-nilly advise some of the Miranda rights just because I had taken them into custody or what have you. Now, when I was required to, I absolutely did, but it didn't... it wasn't something I did just as a matter of course. I did it when I was required legally to do so. Now, something else, if a police officer takes someone into custody and they are not interrogated, just driving down the street in the police car, and the person makes some incriminating statement like, yeah, I really shouldn't have done this or that or whatever, or I knew I was wrong, then that statement is admissible because the officer didn't solicit it in any way, wasn't interrogating the individual or anything else. That's what's called a spontaneous statement. And that would be admissible, especially if it's picked up on the officer's body camera or whatever, some other way that it's recorded, that would be perfectly admissible in court. So again, the Miranda warning applies to a custodial interrogation. If there's no custody or there's no interrogation, then it doesn't apply. Officers don't like warrants. This is another one that I think at least partially comes from Hollywood. You'll see some scene on TV or in a movie where an officer shows up at someone's door and knocks on it and says, hey, can I come in and talk to you about such and such? And the person says, do you have a warrant? No, and the door gets slammed and the officer just has to walk away. And there's this idea that officers don't like warrants. I very much like warrants because whether it's an arrest warrant, excuse me, or a search warrant, when I obtain a warrant, I have presented my probable cause to a judge. The judge has reviewed that probable cause and determined that there is sufficient reason to believe that either something needs to be searched or that someone needs to be taken into custody. That actually reassures me quite a bit because I don't have to worry quite so much about having someone second guess me later on. Now, warrants can be challenged. Warrants can be challenged by attorneys in pretrial motions where they try to suppress the warrant and say the court should have never issued them. But at least when I'm doing whatever I'm doing in execution of that warrant, I'm pretty well covered because, again, it's been approved by a court. And I have authored, I don't even know how many search warrants over the years. I have been party to other search warrants that were obtained by other officers. I'm losing my voice for some reason. Arrest warrants where I have presented information to the prosecutor and it's been determined that there is sufficient probable cause to believe somebody did something. We can issue that warrant. And the nice thing about an arrest warrant is then it goes out on the law enforcement computer system, and if another officer in another jurisdiction comes across that individual, they can take them into custody on my behalf. Now that is subject to some limitations, then there are some things to do with extradition and one thing and another that can come into that. But generally speaking, that can happen. And for the more serious crimes, even anywhere in the country, someone can be taken into custody. So I very much like warrants, and I don't think I'm alone when it comes to law enforcement officers. Now, one thing about search warrants. There is a belief that absent a search warrant, officers can't search anything, anyone for any reason. Now, I already talked a little bit about the stop and frisk, the Terry versus Ohio decision, which is one of the exceptions to the warrant rule. There are other exceptions to the warrant rule when officers can search without a search warrant, and that would take an entire video all of its own to be able to run down each one of those exceptions to the warrant rule. But I just wanted to touch on that and let you all know there are times that that can happen. So there you go. That's my video on common misconceptions involving police officers. I hope it was informative. Again, this was meant only in the spirit of conveying information. I hope that's the way it was taken. So for all of you who watched this, thank you very much. If you like this video and you would like to see others like it, again, this is very easy for me to put together. I could put together a very, very long list of misconceptions. But if so, or if you have any other questions or comments, be sure to let me know in the comment section. So until next time, folks, good shooting. Bye-bye.